All right, well, we're missing one of our speakers. He's in the restroom, but we'll get started with some of the announcements. So I just want to thank you for attending the 25th MCLE Spectacular. I think that's pretty amazing. We've been doing this for 25 years through the Bar Association. Everybody, if you haven't signed in, at the end you can sign in. The sheets are up on the bar here. Feel free if you take a break to do that. Otherwise, make sure you do it at the end. In your packet, you've got your credit slip. Oh, there's a new thing.
Did I miss the introductions?
No.
We're going to dump it all on you now. You were
okay.
We voted for you. So you can fill out the forms at the end and hand those in to rate how well we did or how poorly if you're unhappy with us. But I'm sure you'll give us all fives. Also, our seminar today is actually a lead-in to what the Bar Association is going to be doing next year. And there is, in your packet, an advertising form for the Bar's series next year on law practice management. So there'll be significantly deeper dives. It'll be once a month in the evenings at JFK. So that's part. You can buy a ticket to a whole series or just go to individual classes. So please check those out. The bar is going to be heavily promoting that over the next year.
That's right.
So this seminar here is, so you want to open your own law practice, the 10,000-foot view, and the deeper dive will be next year through the bar. And we've got our experts with us again this year to talk about what we do in the law office. And it's kind of background. This seminar started about 17 years ago, and we're actually coming back to the future because it started with a Lawyers Mutual representative coming up here and talking about all of these subjects that lawyers have to deal with in opening and running a law office from the malpractice and insurance carrier point of view. So we have, again, a Lawyers Mutual representative, and we'll go around and introduce ourselves. So why don't you start off?
Hi, I am Dana Eulis, and I am currently the underwriting manager over at Lawyers Mutual, and we're a legal malpractice carrier that only writes lawyers in the state of California and primarily solos and small firms. So,
Over here to Anina.
My name is Anina Dawson. I am the founding member of my own firm, Dawson Law, which has been around for about 10 years. It's sort of interesting how I came to be a panelist here. 11 years ago, I came to this very same seminar, and I was thinking about starting my own practice. It seemed sort of daunting at the time. The firm that I was a partner of was about to dissolve, and I wasn't sure whether I was going to go back in-house, which is where I started my career, join some other firm, or start my own thing. And so I came to this particular seminar and got a lot of valuable information. It really allayed some of the fears that I'd had, and I struck it out on my own, and it's been fantastic. So I'm glad to join this panel and be speaking about my experience.
Andrew McCall. I've had my own practice since 2002, November, so 17 years this month. And I worked for a couple of other firms prior to that. Really always wanted to be self-employed. Didn't happen right away. Started off practicing with other firms, and then the firm I was with was downsizing, and it was like, well, either I have to look for another job or start my own firm, which is what I really wanted to do all along. So I overcame my fears and did.
And I'm David Pearson. I started out in Fresno doing insurance defense work. For the last 23 years, up until this past October, I was a solo. No overhead, no employees, worked out of my house. As of October 1 of this year, I joined Brother Smith just up the street. And I primarily do general counsel business type work, although my new firm does some probate, and they decided since I was a litigator, I could learn probate. So I'm learning some new areas of the law. So real quick, we wanted to kind of go around the room and just get an idea, introduce yourself real quick and what your interest is, because we like to a certain extent, tailor what we're talking about to the room. And that way we can address your concerns. And feel free while we're going through this to ask questions and give observations. We are not experts by any means. We're going to be talking kind of about what we do in our practices. And she's going to be telling us, oh my God, don't buy a don't do that. So that's kind of how we approach the seminar here. So let's start off here.
Sure, I'm John Dodd. I work for the law firm of Craddock, Hanley & Conti in San Ramon. I'm one of 3 partners in that firm that we are the sole owners of the firm, and we've got about 9 attorneys.
Oh, awesome.
I'm John Schreiber. I practice civil appellate law. Had my own firm for about 20 some odd years. And I'm here just because I figure there's always opportunities to pick up ideas, new ideas that help my practice from other people, and so I'm here to listen.
Great.
I'm Dave Samuelson. For about 38 years, I was an insurance defense lawyer in Oakland and Alameda. And for the last 3 years, I've been semi-retired doing primarily mediations. And I'm here because I may have to leave the mothership and open my own office or travel around or something. So I'm here to pick up ideas in that regard.
Awesome.
I'm Anna. I'm not a lawyer. I'm here at Lawyers Mutual. I'm the Bar Association liaison for the company.
Awesome.
My name is Robert Miller. I work for a firm now with 3 attorneys. One of the attorneys is retiring, so we're all kind of disbanding. I'm starting my own office effective first of the year. So.
Congratulations.
I'm Michelle Ferber. I'm the founder and sole shareholder of Ferber Law in San Ramon. We now have 7 attorneys, and I've been on my own for 5 years when my original partners retired. So I'm here just to see if what we're doing is behind the times, if there's more things we need to do, what we need to do as we grow or stay where we are.
Back.
I'm a sponsor. My name is Suzanne Lawler. I'm with DLC Consulting Services. I hope you don't mind I'm sitting in on this. I think it's all fascinating. We service solos and small firms. We do all the back office stuff. All the non-billable we'll handle for you, whether it's HR, marketing, IT, finance, bookkeeping,
Great.
whatever you need.
Great.
I'm Patty Shimore. I worked in a large firm. I worked in-house, and now I'm thinking about doing something different. So I'm here to listen.
Good.
My name is Bob Salander. I'm the managing partner of Green and Pepper, Salander and Lally. We're 18 lawyers, so I've already started my own firm. But the reason I'm here is that I'm going through the process of updating systems and changing some of the ways we do things, and so I'm interested in hearing those ideas.
Great.
I'm Janelle Welling. My background is I've had about 19 years in class actions on the plaintiff side, and I'm currently on a year sabbatical, which has been lovely. But it also is the opportunity to figure out, do I want to go back to that practice field, or do I want to do something different or something, as much as I love the class practice, it is a little bit removed from a lot of the people that you help sometimes. Maybe I want to do something a little more personal. So I'm here to just learn how I might do that.
Awesome.
I'm Daryl Yasutake. I'm with a 2-man firm. We've been together for about 23 years, doing primarily insurance subrogation work. And my partner's retired in February, so I'm kind of deciding what to do in terms of structuring the new firm.
Hi, my name is Michelle McGrath, and I have a workplace investigations practice based in Lafayette. I'm in my 8th year. I also do Title IX investigations, and recently investigations into patient complaints in the healthcare arena. And so I, like so many, are here to see if I've been doing things the right way, and if there's a few things I can learn. I'm sure there are.
Good afternoon, my name is Ray Robinson. For the past 28 years, I've operated a litigation and trial support firm and a real estate firm. Next year, I'll be transitioning to actual practice of law. And I'm looking forward to starting my own firm.
Hi, my name is Courtney O'Brien. I'm an attorney at a firm called Bishop Berry in Emeryville. We do civil litigation defense. We are a 14 attorney firm. Several of the attorneys are semi-retired or thinking about retirement, and I'm thinking about being a shareholder in the next 2 to 3 years.
Awesome. It sounds like we have a very experienced group. Half of you could probably be up here teaching this. So hopefully we have something to offer. So we're going to lead off talking about office location. And the way we're going to do things is start out with our expert from our carrier, kind of talking about the carrier's perspective, what they're looking for, and what you should or shouldn't do. And then we'll talk about how we kind of do things in our offices.
So, from the carrier's perspective, we're really looking at where are you, is there confusion? Are you a solo who's sharing office space with somebody and it appears that you're really bigger than a solo? Are you a solo who's sharing office space with somebody or a small firm with a solo there and it looks like maybe you're a bigger firm than you really are? Are you working in a location that you are able to secure client documents and files, if you have the originals of something, to make sure you have confidentiality. And so really the questions that we're asking when we're looking to see is just wide gambit, but to make sure what you're doing is not misrepresenting anything to the public and that you're really able to secure what you need to secure as an attorney.
Have you seen anything? And you do actual in-field audits, or how does that work?
No, we trust you.
And how has that worked out?
It works out pretty well. I mean, really, we're not out there auditing. We're not doing in-field audits. We're trusting what you tell us is the truth. People, when they apply for insurance, are signing an application. We're going to take that as sworn-in members of the bar that people are telling us the truth when they do sign those applications. And yeah, so no in-field audits.
From an underwriting perspective, is there an issue if a person decides to open up like a home office and work virtually as opposed to brick and mortar?
Not a problem at all. A lot of people have just a home office even in this day and age where it's so digital, where somebody can have just their home office and then work out of like a Regis or a WeWork or something like that for client meetings and depositions and stuff, so.
So my experience is I work in a small office in Walnut Creek, and I share, it's a suite where there are other professionals working. There are 2 lawyers now. We aren't affiliated one with the other. And then there are some financial planners, wealth managers, advisors. So the important thing to me is to have the proper signage outside of the suite in the building lobby that designates me and the other lawyers having distinct practices. When people enter my office suite, there's kind of a lobby area with someone who greets them and will direct them to the right professional in the suite. So I'm hoping that I'm making enough of a distinction. And then as far as securing files, I have locking file cabinets. To the extent I keep paper files, which is very little these days. I have a safety deposit box at the local bank where I keep original stock certificates and things like that to the extent I'm pulling those for clients. I was talking to these guys last night. I have a place in Mexico and I work out of that Mexican office when I'm down there. And so I just feel like between the virtual office and the physical office in Walnut Creek, it serves me very well and it's good.
How about you, Andrew?
Well, for 20 years, I was in an office on Newell Avenue that was actually where I was working 20 years ago as an associate with the law firm that had, we had a suite there on the top floor with those of us in the firm, and then plus a few solo practitioners that were subletting, offices within the suite. And then when I mentioned earlier, 17 years ago, I got laid off and decided to start my own firm. And the partners at the law firm that just laid me off said, by the way, you're welcome to stay here and pay us rent and sublet from us. And so I did for up through last year, and that worked out great. It was it was a great location, and I never really thought much about being not associated. I was my own firm, so there wasn't. I never put much thought into that, but. It was a great situation. It was kind of unique in the opportunity that I had, so it wasn't really useful for most people attending this, because if you don't have that opportunity, then you can't just do it. But a little more interesting perhaps is the situation now. At the end of last year, the partners retired, and that suite was then, there was a new main tenant in that suite that was a different law firm. They were happy to have us continue subletting there, but they wanted us to sign subleases and all kinds of stuff. And I just thought, it's a good time to try working from home, to just save some money and not have to deal with the different people in the suite and how that may go or may not go. And so I've been working from home for the last, since January. And I have a, Pacific Workplaces is the name of sort of a Regis competitor where I can meet clients and my mail goes there, and it's on Buskirk and Pleasant Hill, Hookston Square, if everybody knows where that is. It's a nice place. They answer my phones too. It's very affordable. I paid for 12 months up front, and then they gave me 2 months free, and that was about the same cost as like 1 month of rent at the office I had on Newell Avenue. So a big savings money-wise. It's worked okay, although I would say that being at home, the home office thing with 3 young kids, it's
Great.
it hasn't been great for productivity. So I'll put it that way. I was more productive when there was separation. I went to an office. When I was there, I was at work. I was working. So I'm missing that separation aspect of it.
So I worked at a firm first, but I worked out of my house for 23 years. And I think a lot of it, depending on where you want to work, is what your practice is. I didn't do family law, I didn't do criminal, it wasn't a concern that people knew where I lived, where some practices you probably don't want your clients to know where you live. My practice is general corporate counsel work, so I almost never see my clients or I go to their office. So working from home, I actually quit the firm and started when we found out my wife was pregnant, so I worked from home up through my daughter's college. And so it depends on your personality. Some days when she was homesick, I had to pause the phone and say, hang on, my assistant is calling me, and be with my daughter. So, there are ups and downs from working from your home, and Andrew's now going to find those. So, but I enjoyed it. Now I'm back working in an office where we've got staff, and I have to actually put on not shorts and t-shirts and show up for work. So that's been a different experience.
I think also, go ahead, John.
I really enjoy working out of my home as an appellate specialist. It's just so much of my work is just online, online or on my laptop. Files are more and more just becoming almost strictly online, virtual. And so I very rarely need to meet a client. Most of my clients now, I speak to telephonically, and I don't usually need to meet them. Most of my referrals are through trial counsel. And so it's very flexible. If you can really focus when you need to focus, there's a great deal. Fortunately, my kids are grown, so that's not the distractions of that is not there anymore. And as long as you can find time to focus and get into routines, then it's wonderful. Because you do have the flexibility to wear shorts and shorts and a shirt or whatever, be comfortable.
And when work is slow, your spouse will appreciate you doing the housekeeping, laundry, and having dinner ready when they get home.
I think it's really important to understand yourself, though, what kind of worker you are. I'm the sort of person that feeds off the energy of other people working around me, and so I find it difficult to work in isolation. I'm not as productive as I am with other professionals kind of feeding me their energy. So working from home for me does not work for a number of reasons, but that's one of them.
Well, I've talked to people who work at home primarily, and one of the things they complain about is shutting the door at 5 o'clock and being done with it. As opposed to, you have your computer out, you've got your phone out, and sometimes it's hard to shut it off, especially if you have clients that are calling you and wanting information.
All my clients have my cell phone. Doesn't matter whether I'm in an office or home or halfway around the world. You unfortunately nowadays you can be reached and the clients know it. So our next topic is financing, which...
I'm sorry, just a real quick question on the signage, because like you, I sublease. Like you, I don't see clients at my office because of the nature of my work. I go to the client or I go to a neutral space. Occasionally they want to use a conference room, but it's very, very rare. So I don't have signage that's unique to me. Is that important? I mean, I'm just wondering why you raised the importance of signage and distinction.
It's not as much signage on the actual physical office location as how you're putting yourself out there. You're putting yourself out there on your website as being part of this firm that you sublease from. Are you on their website? Are you putting yourself out there on your letterhead with your firm name and then their firm name somewhere on it? So it's, like I said, we don't do in-field checks. We're not looking at the actual signage, but you just want to make sure you have that distinction and separation just to anybody kind of looking in from the outside.
And I think if you had this sort of practice where people would just come in to find you as a lawyer and saw you in this greater organization, if I were the other organization, I'd be worried because you may be giving them bad advice or whatever, and when they bring a claim, they're going to sue the bigger law firm and say, well, I thought that she was with them. I had no idea she was a separate entity.
Got it. Okay. Thank you.
So financing, what from the malpractice standpoint, besides being able to afford your policies, which is always important.
Just like, how much is a malpractice policy for a solo?
So it really varies, and it's really unfortunately not this is a hard number answer. So I know that what we do is we actually rate by areas of practice, and if somebody works full-time or part-time, and actually what county you're in. But Contra Costa is kind of the middle of the range county. It's not as bad as being in San Francisco or Santa Clara or it's in LA. So it's really all over the place, and something like a criminal law attorney or an appellate attorney or a full-time neutral and somebody that is in a practice area that has a much lower risk of being sued is a much less expensive policy than somebody that's doing class action work full-time on the plaintiff side. I mean, those are probably actually the two complete opposite ends of the spectrum. So it really does vary, but any carrier, and I know that we do it at the very least, can always give you an indication over the phone. So when you're really looking to start out or starting to put the numbers together, call us. We're always happy to give an indication. I'm sure other carriers will do it too, but that you can get a ballpark number of what you're really looking at for what you're going to do when you're putting together your budgeting.
What if you start out with a limited practice in certain areas, and then as time goes on, you expand? Are we required to contact you there?
Well, I can speak to what we do. So at Lawyers Mutual, we ask every year when somebody applies in at renewal exactly what it is you're doing at that time. And we look at a 3-year history, but if you're starting out fresh, it's what do you intend to do? Are you intending to be a 100% criminal law? Are you intending to have a hodgepodge all over the place, and what kind of breakdown are you looking at? And then just each year at renewal, we have areas of practice updated, and at that point, the attorneys or the firm will let us know how it's changed, look at rated slightly different in their individualized premium as to what their actual areas of practice are, but you're not prohibited from doing something else. So if somebody is defense firm with us and they get a PI case that comes in, they're not prohibited from taking that PI case. They just need to let us know at their next renewal so that their price can be adjusted accordingly.
The rate won't go down, right?
Out of curiosity, you said the rates are based on what county you're situated in?
So for us, they are.
Why?
Yeah, because different counties have different risks of lawsuits. I mean, and anybody that's a trial attorney, it's no different than the jury verdicts and what you expect when you go into trial.
But within today's practice, my area of coverage is from the south border of Oregon to Fresno. So I'm just curious why it's just...
I get it. I practice throughout the whole state.
Yeah.
I come from an insurance defense background.
Okay.
That's what I did for 15 years. So, I mean, but I totally get that. And it's not one of the major factors.
Okay.
The
I
main
just was
thing
curious.
we're looking at is what you do and what your areas of practice are. But county has a slight play into it. And if you're in like LA County, if you were down there, you'd be charged more. Here, like, it's not as much of a difference.
So how did you start your firm?
How
Did
did I
you
start my
have money?
firm? So I put together a business plan. Before I started my own firm, I was fortunate enough to have a book of business from my other firm to bring with me. So I kind of had a ballpark idea of what I thought my monthly revenue was going to look like, more or less. And then I, looked into office space, and that at the time was going to run me about $1,000 a month. I had some staff that I'll talk about during the next topic, and so I needed to make sure that I could cover their overhead, malpractice. I did a business plan and a budget. And then based on that, I figured I had enough. I have a line of credit that I got from my law firm, but I've never really had to tap into it. It's something that I just keep as an emergency, but fortunately have never had to really dip into it. So I was fortunate not to have to go into debt to start my law firm. It was pretty much a shoestring budget. I was lucky enough to have receivables on a monthly basis to more than cover my expenses. But I also felt it was important just to have the safety net of a line of credit, which I got at City National Bank.
On the book of business issue, one of the approaches I thought about was buying someone else's practice in their book of business, like if they're retiring now. And I wanted to know if any of the panel members had any experience or did any research, or even the participants, with regards to buying someone else's practice as they're going out.
I love that question because I was at the seminar that was about how to end your practice, and I'm looking sort of I've got 10 years
She's
at
much
least
older
to
than
go.
you look.
But it's something that I feel like I would like to start thinking about that. I don't really have a succession plan, and I feel like I've worked for a long time building the value of my book of business, and I don't really have anyone to sell it to at this point. So that's something that's in my mind now. I was fortunate enough that my firm dissolved and there was just a group of clients who came with me. I didn't have to acquire them. They just already worked with me. But I would open that up. Did anyone buy
Has
a
anyone
practice?
looked into it or know someone that?
I started to with another solo. When he was retiring, I had done a lot of work with him because he didn't litigate. He only did transactional and I did both. So I helped with a lot of his litigation cases. And as he wanted to go towards retirement, he looked at me to start taking over some of his work, and we entered into an agreement where I would pay him a percentage of whatever revenue I received off of his clients that I moved over into my system. Over a period of like 2 years, I think I paid him a percentage of what I billed them.
And would he still stay on like the firm and you just
No,
gradually
he
transition, or I'm seeing you later, I'm going?
He kept his practice going for a while, but the clients that transitioned to me, I had them sign my fee agreement. They became my clients, and it was on me. He was done with that, and then he decided to unretire, and he kept the remaining clients that he still had, and he went off, and I had the few that I bought, so it didn't cost me anything because I was only paying him as I collected revenue from them.
Okay.
So there was really no downside, but
Anyone else looked into it, or?
Ms. Ferber.
Yeah, so, I had a really short window when my two partners decided they were going to retire. And so I had opportunities to go on my own or to bring someone with me or to sort of keep in place what I had helped them grow over the last 10 years that they had started, 20 years before, and to keep our staff and to stay whole. And I decided to stay whole. And one of my partners rented an office from me, sat next to me, and really did retire. You just want to have a place to come. The other one didn't really retire, because some people just have a problem with that. They think they want to and they change their mind. You have to be prepared for that. He changed his mind about 20 times. It's a hard thing when it's your identity.
Right.
So it was we made a deal, and it was sort of the same sort of, we wrote letters, and then if clients wanted to become now part of Ferber Law, they signed a whole new agreement. We gave back files. It was a huge process. And for a certain group of clients, I paid, in addition to what our partnership agreement had sort of anticipated for retirement, a fee over time. And I contributed a little bit of cash, but I didn't want to put a lot of cash in. And I had a big staff to keep over, and our staff had been with us a long time. I've had people now who've been with me for over 25 years. So health insurance was important, even though we don't have to provide health insurance. It was an important benefit. So I talked to a couple different banking people, and I went a very non-traditional way because I had really good credit. I got every credit card you can imagine that had points for 18 months, no interest if you pay it back in full.
Okay.
and I set up the plans to make the right payments, so I never paid interest.
Okay.
And I got a lot of cash that way for that first 12 months without accruing, minimal fees when you open them, but no interest if you're disciplined about doing it. And that's how I did it. I now have a line of credit, like Ann said, don't use it, haven't had to use it, but it makes me feel better at night. So I didn't want to put a lot of my own cash in.
I'd be hesitant to pay money up front to somebody to take over their practice, because while those clients may love Anina, they may come to me and hate me, and then they go away, and I've paid her for those clients, and they aren't going to stay with me. But if I pay her a percentage of the revenue those clients generate that stay with me, then I'm basically accepting a lower fee, but I'm still generating cash for myself, and I'm paying her. It's basically an earn out. So you see that frequently with the sale of smaller businesses where you pay little to nothing down and the seller earns out what they get paid.
And would that affect the cost of malpractice insurance if you buy it? Okay.
So did you have any?
Well, I guess my experience with buying out a practice was that I decided not to at one point. I do family law, and in the office suite I was in, there was one of the attorneys who'd been doing family law for a number of decades, had a great book of business and things. He was retiring and going to go to seminary and become a priest. So he said, hey, I want to sell my practice. Would you like to buy it? And I considered it briefly, but I was busy enough with my own cases, my own clients at that point, that I wasn't interested in that, and I wasn't interested in paying him for a bunch of clients that, well, why would they stick with me when he's the one that brought them in. So I didn't see the value to it.
So was he proposing an amount up front, or a bold, a hybrid?
We never got to that point.
I feel like a really good approach for you to consider is to find someone who's kind of thinking about retiring and maybe working with them for a year or two and kind of shifting the cases to you and paying them a percentage of what you could have like David did.
Yeah, that approach seems like it would be ideal and safe,
Yeah.
especially if they decide to come back.
Right.
Well, and you're going to hear later on about some of the requirements solos have under the state bar and some of the malpractice insurance. So that'll play into working with another attorney. So why don't we move to staffing, which is actually a big area, especially since, as everybody knows, and Michelle's been doing seminars for over a year on AB5 and Dynamic's case. So how does the carrier look at that and our ethical duties we have with staff?
So from a carrier perspective, your support staff, if you have for a ratio of more than 1 attorney to 3 support staff, we're going to ask questions. We're going to want to know. And obviously some areas of practice lend to having more support staff than other areas of practice, but we are going to ask questions and want to know why you have so many support staff per attorney ratio. Another thing, and if you're adding an attorney to your policy, but you're not adding them as an employee, you're considering them an up-counsel or an independent contractor, and that's when you can still consider them an independent contractor coming down the line, we don't automatically cover them. So support staff and paralegals, secretaries, everything like that would be covered under your policy without being named, but any attorney touching the policy, even if it's a contract attorney coming in to do 20 hours of discovery work for you, we don't cover them unless they're actually added onto the policy.
So would we have to email the carrier if we brought in a temp attorney and say, I'm adding Anina for a month, can you put her on the policy, or how does that work?
For us, you would need to. We have a 2-page application, and if you're not with us, I would say you should find out from your carrier what it would require, because everybody's slightly different, but it's definitely something you need to let your carrier know and find out really if they're covered or not, because they really may not be.
So what if our staff comes from a temp agency where we're going to like ADP or one of the staffing companies, and they're providing our secretaries and paralegals, so it's not our employee, but it's kind of a co-employment. Do we list them on your policy? How does that work?
So that would be getting into the employment realm, and I would probably defer to Michelle on that, actually.
Do you ask those questions though, or is it just how many people are in your office and we don't care kind of status-y?
We ask what your staff is, we ask who's in your office, we look at letterheads and websites, and we Google you and we see what kind of comes up for you and if you're being associated with other people out there. If you have other attorneys on your website you're not telling us about, and we'll talk to you about that. If you tell us you have enough counsel, we'll talk to you about that and we'll ask questions. But really, that's it. If you have somebody we don't know about and you're not covering them, well, really, we don't know they're not there. We don't know that we don't know about them until there's a claim, and then there wouldn't be coverage for them.
What if, let's say I'm working on a case and I'm insured with you, and I want to bring Andrew in an association to work with me on a particular case. Am I required to report that to you, or is there no coverage problem there?
If he's in a counsel or just a co-counsel situation, that's not something we would expect him to be added onto your policy. But you may on your own want to find out if he has insurance and confirm that he does, because if you're in a co-counsel situation and he's not necessarily part of your firm, well, if you get sued, he's probably getting sued. And we all know deep pockets is where people go to or where the policy is. So it's something you should always be aware of.
So there's no exclusion in the policy that says I can't associate with someone without letting you guys know?
No, there's no exclusion about that, just things you want to be aware of on your own at that point.
So speaking of staff, I learned something interesting last night. We had dinner, and it came up like who you work with. I have one staff person. She's a paralegal. I've worked with her for over 20 years through different firms. And she works with me 2 days a week. She also works with 5 other law firms. She works through a limited liability company, does bookkeeping services, paralegal services, etc. And I feel confident that even under the new AB5 rules that she's an independent contractor, and I don't lose sleep over that at night. What I learned last night, though, is that I hired someone to redesign my website a couple of years ago, and it's very flashy, and it's got some great images on it, but there's an image of a meeting of all these people who don't work at my law firm, you know? And so we were talking last night, that's something that never even occurred to me is, you know, what image am I putting out there? You know, it's at my law office is called Dawson Law. It's not Dawson Law Attorneys at Law. It's not Dawson and Associates. But if you were to pull up my website, you'd see like this whole group of people. I don't know any of them. They're all beautiful models. So I'm reconsidering the images that I use for that purpose.
Yeah, so, I mean, for myself, as a solo for 23 years, I think one time I hired an outside paralegal. She was a temp through one of the temp agencies for one specific case because I needed an assistant who spoke Spanish, just for one matter. Otherwise, I mean, I did everything myself. So from soup to nuts, I was everything. So going to a firm now, it's definitely kind of a weird feeling having an assistant saying, what can I do for you? I don't know, I know how to run the business. So, you know, as a solo, you've got to decide, because I started an insurance defense firm, and I went out on my own, and I'm a tech guy. I love tech, so I have every toy you can imagine, so I'm good with that. But you've got to understand, as an attorney, a lot of people don't know, what does it take to actually do a proof of service? You know, when you have to do a mailing, what is that going to take? And a lot of, I mean, I think most of the partners at my firm would be completely lost if they had to actually serve a complaint on their own or fill out a pleading form. It just isn't going to happen. So you have to be comfortable yourself if you go out on your own or start a firm. What is your level of comfort? And if you're not comfortable doing those things, you're going to have to hire somebody, whether it's an employee or somebody through an agency or temp. And what's that going to cost, which builds back into financing? You have an employee.
Yes, I have an employee, and what's interesting with her is I pay her a straight amount every month. I pay her the same amount. And I haven't raised her compensation in a very long time. And I'm thinking I want to do that, but I don't want it to cost me anything. So I think what I'm going to do is build in kind of an incentive where she is a paralegal as well as a bookkeeper and business manager, and I think I'm going to let her earn a portion of her billable hours. So the more money she bills, the more she'll earn. So I think that's what I'm going to do with her going forward. There was a question down here.
Yeah, I was curious what constitutes staff for purposes of the 1-to-3 ratio, because we have file clerks, we have secretaries, we have paralegals, we have IT, we have accounting. Are they all staff?
They're all staff, but like I said, it's not a hard ratio, but it's a guideline. If you would come back, say you were a solo, and you came back and you said, I have 5 support staff, not 3, but each of them served a legitimate purpose, then we're okay with it. We're really trying, but sometimes we get back where it's a 1 to 20 ratio, where it's some kind of firm that will say, oh yeah, we have 20 people running cases out there and really practicing law without being attorneys. And so that's really what we're looking to avoid and looking for our insurance to avoid.
Is there a sort of like a sweet spot in terms of actual attorney to people who are directly assisting the attorney, whether it's paralegals or secretaries?
That's really the 1 to 3. Like if
So
the
that's a
IT,
sweet
the
spot.
bookkeeper, the receptionist, those are a little bit different. It's kind of the 1 to 3 ratio on who's actually supporting the attorney is really the more sweet spot for using your
Okay,
words.
and does that include associates?
No, those are attorneys and they each get their own support staff in that ratio.
Okay.
Yeah, staff, me, myself, and I. You know, my motto has been keep it small and keep it all, you know. Whenever money is there at the end of the month, I don't have to write anybody else's paycheck, and it's mine, which is nice. The downside to it, of course, is that nothing happens, nothing gets done if I'm not there doing it. So there have been times where I considered, you know, maybe it's time I hire somebody, but I've never actually done it. I think the closest to support staff I had was when I moved my office home back in January. I got my oldest son over there with me to help move furniture and boxes and stuff.
Make him earn his keep.
Yeah, he did, he worked hard.
On the staffing issue, about 10 years ago, I was doing contract work for a big firm in San Francisco, and they were only paying me like $45 an hour for the night of work. And I came across the billing that they were billing the client that was like actually $195 an hour for my work. And I'm sitting there and I was like devastated that, you know, they're getting all of this money. So my question is, those that have staff, do you mark it up? And if so, where's your ethical barrier as far as how much do you mark it up?
I don't know that there is necessarily an ethical barrier on markups. It's what the market bears. I mean, most law firm models is to have, you know, equity partners, partners, and associates. And you know, you're feeding that pyramid. The associates get paid a smaller amount. And like, I came from insurance defense initially. We got paid very little. And we had to work a lot of hours to generate revenue for the partners. I mean, our minimum billing back in 1991 when I started was 2,000 hours a year. And we were paid $42,000 an hour. Or $42,000 a year for 2,000 hours. And the 3 associates that started, 3 guys, we were all married. We compared our salaries to what our wives were making, and one of the guys, his wife was a clerk at Macy's, and she was making more on an hourly basis than we were making.
But the State Bar website has some good sample representation and retainer agreements, so that if you were going to use of counsel or temporary quote contract per diem attorneys, so that the clients are aware that you could be using them, and then it's whatever the market will bear because you've ethically disclosed that you're using other people. So I would look at those. I think the State Bar ones are really good, the retainer agreements.
Just as far as a general business model, I find like 4 times is fairly typical. You mentioned 45 versus 190. That's in the ballpark. I mean, 4 times 45 would be 180, right? So I mean, it's that's
I would say
not
it's,
unusual.
as someone who's an associate, so they're making a lot of money off of me, I would say that that's pretty accurate.
Why are you here? You should be at work.
That's why I say that's
Well, and I don't have any employees, but I've been doing a little bit of research, and one attorney told me like this rule of a third, a third, and a third. So if you're going to pay like an associate attorney, you know, a third would go to your overhead, a third would go to them, a third would go to you as the business owner. I don't know if that's...
That would be amazing if that really happened.
Yeah,
I wouldn't be sitting here today.
in the Bahamas.
I'd be in Mexico.
Wow, wow.
It's a good rule though.
Good rule of thumb.
It's a good goal.
So next is marketing. What, from your perspective, do you look at our marketing campaigns, or do you care?
So this kind of I've already touched on a little bit. We do look at what your website shows. We do look at what your letterhead says. We do Google you and see what's out there. And it's like I said, don't put yourself out as having more attorneys than you really do. Don't make yourself appear to be a big firm when you're not a big firm. A couple other things is if it's a solo, we don't allow the use of attorneys with the S on the end. It has to be attorney. If it's a solo with no staffing at all, like Andrew, you can't use the word group on the end because that makes it seem like you're a big group of people. And so it's really, we're gonna now. No, but so it's just not misleading the public. It's putting yourself out there as what you really are and not misleading the public into thinking you're something bigger than you actually are.
And do you ask about how we go about actually marketing our practice, or you're just looking at the representations kind of made on the website?
No, so we do not ask about what you're actually doing. It's more what we find and what you give us through letterhead and website addresses.
And Anina, you had excellent marketing suggestions a few years ago. You talked about going to a convention of a specific industry that generated a lot of work.
So I do work for dental and medical practices, and so some years ago I got introduced to someone from a group called Patterson Dental, and they're providers of all kinds of dental equipment. They lend money to dentists to buy practices, to buy equipment. They put on kind of educational seminars for dentists, and so I got invited to give them seminars on employment issues for dental practices. Well, there's no such thing, right? It's just a small employer. But dentists loved it, and they really felt like it catered directly to them, and through that, I became sort of the lawyer to the dentist. So that's like an area of my practice now, and they all refer to each other because they all very much trust each other, and to this day, I'll get referred to someone, oh, Dr. Jeremy Bartlow recommended, I have no idea who that is. So that, and then also in the packaging industry, I have several clients that are in the food packaging industry, and so I've gone to trade shows there and handed out cards, on the showroom floor, and I've gotten some good business that way as well. I joined a group called Provisors. That's where I met Roger Brothers about 8 or 9 years ago, a professional advisory group. And what's nice about that, it's interdisciplinary, so you meet not only attorneys, but accountants and other real true referral sources. That particular networking group is expensive, but it's really high quality.
$1,800 a year.
It drives results, though. Like, you get really good contacts and good clients from groups like that.
It's definitely, that one, I mean, I'm a member of Provisors too. It's definitely depends on your practice area as to whether it is worthwhile. For business attorneys, it's great. We've got family attorneys that actually generate quite a bit of work out of Provisors, so think about what your practice area is. And Provisors is very attorney driven, so they base their groups around a core group of attorneys in practice areas, and then they bring in other kind of support services that fit in with that. But they're all over California, and they've been expanding across the U.S. So how about you for family law?
Yeah, marketing, done a number of things over the years, some of which has worked and some not so much. With the firm I worked for back 20 years ago, we got a lot of our business from union legal service plans. And when I started my own practice, one of my first phone calls was to the legal service plan, and I let them know that, hey, I'm now on my own, and they knew who I was, and so yes, we will send you clients. And so that has been a big source of business for me over the years. There are a number of other, union benefit plans, but also, like employer-provided plans. ROG is one of them that a lot of employers offer that as a sort of legal insurance. Legal Shield is one. There are a bunch of others. Prepaid legal services was another.
Have you done the Bar Association?
Yes, I have. Some of those plans work better than others, and within for your practice area, it may make more sense. One plan versus another plan. The Bar Association, the LRIS, I believe it's called now, Lawyer Referral and Information Service. I signed up on that when I first started my own practice 17 years ago, and it was great for the first few years of my practice. And then after the first few years, they continued to send me people, but it seemed like everybody they sent me was, well, thanks for the advice, and I'd love to hire you, but I have no money. Because the economy was really down at that point, and everybody's home equity line of credit was frozen, and so they had no ability to hire me. So I had a feeling, you know, one time when I was renewing my bar membership, and do I want to pay to be on the panel? It's a nominal fee, I don't know, $60 a year or something. But do I even want to pay? Because I feel like this hasn't been any good. And I track all of my, initial interviews, and I look back and I saw, oh, the last year, the LRIS gave me absolutely zero in the way of, paying business, because, the initial interview is free as far as you as the attorney. So I stopped doing that. I did business networking groups like Provisors has been mentioned. BNI, I think, was the original big one. I did that back in 2003, my first full year in my own practice. It generated some not a whole lot of clients, but a couple of really large clients that paid, and so that was really good. I was so busy after the year doing that, not entirely from that, but that I decided not to spend my, it's mandatory attendance BNIs every single week, like a 2-hour meeting at the crack of dawn on Tuesday or something. And it's like, my time is better spent sleeping or in the bed at this point. But, so that can be a way to build up business marketing. I've done some other networking groups in more recent years. I found I was spending a lot of time at these meetings and wasn't necessarily generating business, so I've stopped doing those.
One of the suggestions that I wanted to make was this, is sometimes the best source of referrals are your own clients. And we don't think sometimes about asking our clients to refer us business. And so when you've concluded a matter for a client and you know they've been happy with you, I think it's worth writing a handwritten note or calling them and just saying, I've really enjoyed working with you. I'm glad that you're satisfied with the results I've delivered. And what I really would like is if you could get the word out that you recommend me. And I feel like client referrals that come from clients, those are good referrals. Those are people who aren't going to stiff you on fees, or usually quality people. And I feel like that's the best source of business.
Joining the solo board is always good. You could be up here speaking next year. I actually got quite a bit of business from joining the solo board and meeting other solos and having people who had complementary practices. Like, I don't do a whole lot of employment law, so knowing people like James Wu and our esteemed colleague down at the end, having those people that I can refer that kind of work to and they can refer work back to me that they don't do in the general business area is a huge plus. And so I think, people at Contra Costa Bar going to events and getting your name out there, meeting people is a huge plus.
What about television commercials? Look into the cost of that, because the only ones I see are like these mass tort litigators, and I'm like, wow, it must cost a lot, because I don't see any solos doing it.
I have something.
In the past, I actually had to litigate a case when they used to have yellow pages, phone book, and you would see those full-page ads from the personal injury and the divorce attorneys. That was actually the Yellow Pages, one of their biggest sources of litigation for collections actions, was suing those attorneys who would take out those big ads. It wouldn't generate the revenue they thought it would generate, and the Yellow Pages would sue them left and right.
Wow. Yeah, one of the firms I worked for 20 years ago, we got quite a bit of business from the Yellow Pages. The firm ran a big, like, half-page ad in the Yellow Pages. We did family law and personal injury. And it was, a free consultation and called a number. And it was, we had a secretary that would answer the phone calls and book the initial interviews, and it was kind of a numbers game, But I didn't have to answer the phones, so the secretary would do that, and so it kind of worked that way and brought in a lot of business. When I started my own practice, I thought, well, I need to get my ad in the Yellow Pages too, and I was shocked how much it cost. And then, yeah, you're stuck paying for it because if I didn't pay for it, they were going to cut off my phone because it was a phone company. So
Number.
yeah. Fortunately, I didn't. I decided to go with a smaller ad. And it generated nothing but a few garbage calls. A few people looking for free. What information they could pump me for over the phone. And I didn't have somebody else answering the phone for me. And it really didn't generate very much at all, so after that experience I stopped. So yeah, that's one reason I like things like the lawyer referral and information service was just a percentage on the back end. If you bring in money, you pay the Bar Association 15% or something of what you collect after you collect it. I like that situation much better than the laying out the big bucks for the advertising.
But if you like TV advertising, Google the Texas Law Hawk. He has the most amazing commercials you will ever see.
Texas Law.
And they're all over the internet. He puts them up on YouTube. They're the funniest things ever, and he does a good job. So,
yeah, I was just curious.
But before you do what he does, make sure you talk to the state bar and make sure you don't cross that line.
Right.
Because he's pretty darn close, I would think, in California. I don't know about Texas, where he practices, but they're pretty inventive commercials.
What about the flip side of everybody being a journalist on the internet now, and every Yelp and reviews? What about I've certainly seen these services advertised to your reputation protection, right? For lawyers, or that scan if anybody's written a bad review or.
So from an ethics standpoint, you can have those services tell you that somebody gave you a bad Yelp review, but you can't do anything about it because you ethically cannot respond to those. You'll get in trouble with the state bar because you have to keep client confidences. So, well, you can do a generic kind of response. You can't really do anything specific, and those people are free to do what they want, unfortunately, on the internet. So be very, very careful how you respond to those posts, and make sure you read the ethics opinions from the state bar so that you don't get in trouble because one of these people slammed you with false and malicious publication.
I got just a general question, just on just having a website, just in case somebody does want to Google or look up, like, how do you get like a decent website going along?
Don't ask me.
You get the general.
Picture of really pretty people.
You go to Wick and start one up, but then how do you get it like? Is it better to find somebody to help you?
Yeah.
You want somebody you want to hire a professional to do it, and then just having that website is not going to be sufficient because you also need to drive it with what's called SEO, which is search engine optimization. Mm-hmm. And that's where you're having somebody come in who optimizes the keywords and how your website drives so that when somebody types into Google a search phrase, the keywords that you're paying for you are more likely to come up on the first page of Google, because all the research shows that if you're not on that first page, if you're in the second or third, your results drop dramatically. So I have a client who does SEO. They make a tremendous amount of money doing that service. It's almost all cash that drops into his pocket, but it is hyper effective. And every big website hires SEO companies, and it's technically in violation of Google's terms. And most of the companies that do SEO, their clients only stick with them for a year, then they'll hop to a competitor because everybody has their proprietary methods. And if you stick with the same company for multiple years, you're more likely to have Google catch you than Google will block your website for a period of time. You'll basically be put in Google jail. So, but they're very effective.
So basically just find somebody that knows what they're doing and getting a website going.
I would recommend different attorneys that you know that you like how their website looks. At the bottom, it will say who did it for them in like little type.
Okay.
And then you know kind of where to start.
Okay.
So question to you.
It's also important, I think, to when you have a website, you've got to keep the content fresh and updated.
Right.
Yeah.
Because otherwise, if you haven't done that, your website will move downwards in terms of the search engine.
You don't want it to look like MySpace.
Well, and I remember being at like this seminar, I want to say maybe 9 years ago, and there was this whole topic about internet and using the internet for clients. And there were attorneys in that room that said, I would never take a client from the internet, don't want a website, I'm never gonna get, that's not my kind of clients, that's not right. Well, the truth is, even if I don't really get my clients from the internet, although because we're in Bishop Ranch, there's a search part for that sometimes, but no, even though they're not coming from the internet, I think 98% of them look at our website before they decide to call us or make an appointment.
Right, that's all I'm kind of looking for.
Yeah.
Just somebody to start, okay, this is good enough. And
Yeah,
then-
I frankly get very little, I'm kind of suspicious of anyone who wants to hire me based on my website. Like, I don't know if it was a client, because why are they looking for my kind of practice? You don't just look up a lawyer.
It's Nigerian princes. Nigerian princes.
So, but I do need, like Michelle said, I need something that to lend legitimacy to who I am and
That's
what
all I'm
I do.
looking for,
And,
yeah.
And so I don't care about search engine optimization, I don't think.
Yeah, I mean, it depends on your practice. I mean, people aren't Googling me as general counsel, but if you're a family law attorney or criminal defense attorney, DUI attorney, those people are going to get Googled.
Do you offer that service, website design?
We don't do it ourselves, but we have people who do it.
You know people.
We know people.
I looked up a case management software company, Smokeball. Has anyone ever heard of them? Yeah, they actually in their plan include the website design and management and updates and stuff like that. But I was just kind of concerned with, your subscription, you don't stop. Does your website disappear kind of situation?
I would go with a third party and have your own hosted that you
Yeah, the
control.
host is the key.
Okay.
So the next topic is kind of intellectual content, and that one, you can take a look at this. Everybody knows where to find stuff now on the internet. It's pretty descriptive. I think last night at dinner, Lawyers Mutual said that do you guys offer fast case if you're a subscriber? Or?
No, but what I had actually mentioned is recently I had learned that the CLA, if you remember, which most of us do pay CLA dues when we pay our bar dues, you get free access to fast case, which is if you don't have Lexis, you don't have Westlaw. That's something worth looking into to see if it's something you want to utilize.
But there's plenty of free internet resources. You can Google Scholar, all those good ones. If you're a member of the solo section, please join us, pay our fee. You have access to JFK's Law Library, and even though the California, I don't know what their accreditation is, since they're only California approved, they're now allowed to not have a library. They just have to provide electronic terminals with access. But JFK has told us that even as they move to more electronic access, our members can go to JFK and log in and use Westlaw and Lexis and whatever services are offered through JFK as part of our membership. You just have to be at their law library using their terminals. But that is part of our membership, so that's a benefit for solos who don't want to pay fees for Lexis and Westlaw.
And I think one of the great membership benefits that our section has as a solo member section is the listserv that we have. So if you ever need a referral for any kind of anything, the folks on that listserv are very generous with their time. I've been just so blown away by how helpful people are and how willing they are to share information, and it's a great resource.
So next big topic, billing. Do you care about our bills?
We do not care about your bills.
We do.
So I'll let you guys take that one.
So you want to start off?
I'll start off. I think the first thing to talk about before we get to billing is your fee agreement, right? Is to have a written fee agreement to make it very clear to the reader as to what that fee agreement is and how you're going to bill for your time. None of us want to be in any dispute with our clients over fees.
And I will add in too, that's actually something we do care about, is that that's something we ask about. Have you sued for fees in the last 5 years? Do you commonly sue for fees? How often do you sue for fees? Because if you're chasing a client for fees through a lawsuit, chances are they're going to turn around and accuse you of malpractice.
And then another thing to consider is when you're entering into your fee agreement, if you ask how much of an upfront retainer do you ask for that in your method of billing? I now routinely do ask for a substantial upfront retainer, and if people balk at that, that to me is some kind of indication about whether this is going to work out. If they're going to balk at the initial fee, maybe that's not the client that I want. I pretty much bill on an hourly basis for the work that I do. Once in a while, I'll do an entity formation. I'll do that on a fixed fee basis. I don't do any contingency fee work at all. It's mostly all hourly work.
And so go to the State Bar website. They have excellent fee agreements available for free that you can look at and use as a model. I would definitely take a look at those, but that's your contract with the client. I mean, you're an attorney. If you have to resort back to any dispute resolution, that contract is going to control the relationship between the parties. So make sure you spell out what you need to spell out, whether or not your dispute resolution is through arbitration, whether or not you require a fee up front, whether it's a replenishing retainer. So you could have a retainer that doesn't replenish and it just gets spent down, and then when it's zero, they just write you a check each month. Or replenishing, when you always have that initial balance in your trust account and they have to keep it there, or else you potentially walk away. So you want to make sure you spell those things out, because if there is a dispute, you're going to have to present that. And the Contra Costa Bar no longer handles fee disputes, so you'll be going to San Francisco with the State Bar.
And I think in my own billing, what I like to do is give sort of a narrative account of my time. It's more detailed than a lot of lawyers do. But I feel that the client then understands what they're paying for. When they get a hefty bill, at least they can see how I've spent my time for them. I know many attorneys don't do that. They don't do that detailed of a bill. And I think that sometimes that's difficult to justify your fees when the client can't see how that time was spent.
And I agree with Eric, I do the same thing. I'm very detailed. I mean, you can just, it's like a chronology of everything I did. You know, telephone call, opposing counsel regarding blah, 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 blah. You know, it's like almost you're writing a whole letter just in your bill, because they look at it, okay, you know.
Yeah.
Well, your bill is really an opportunity to advertise or to kind of demonstrate to your client the work you're doing and you know, sort of, I don't know if to say justify your bill, but really just sort of say, hey, this is why you're being, you know, I'm charging you this amount. This is, you know, this is the work I do.
And I used to do this. I used to look at the bill and find ways to discount. I just looked at the bill and think, well, boy, I spent an hour and a half doing that. It really shouldn't have taken me more than an hour. And for that line item, I would write down my time. But I was really doing myself such a disservice because my client didn't know that. And so what I do now instead is at the end of the bill, I kind of tally up where I think I should have spent less time and give them a nice discount where it says courtesy discount. And then they really appreciate that. You just got a lot of goodwill.
Right, that was a question I was going to ask you about that, because I know that some attorneys will just say, well, I did all this kind of work and I didn't bill for it, but I thought that it would look better if you bill for it and then at the end just do it.
Yeah, I feel like it goes a long way with the client when you do that, rather than just kind of writing it off. And then you've kind of set a bar for yourself, so the next time, even if it takes you that long, you don't want to charge them more because it only took this amount of time before kind of thing, and you shoot yourself in the foot.
I mean, you Andrew, in family law now, you can be very different from like the corporate business side.
Yeah, I would echo a lot of what Nina's saying. I learned, you know, my first job was with an insurance defense firm, and we were expected to bill 2,000 hours, you know, a year. So, you know, billing was everything, but, you know, all the bills were going to the insurance company, and they've got a whole staff that does nothing but, you know, nitpick the bill. So it was, they were very adamant that, you know, you bill everything, and you be very descriptive about what exactly it is that you did, because they're gonna, you know, they're gonna mark the bills down anyway, but, you know, the more you can justify it, the better. And I think, so I've just kept that with that as, you know, doing my own thing. I'm very descriptive, and so I want it so that, well, if anybody ever questions a bill, I can look at the bill and I can see exactly what it was that I did. And as it is, you know, I'm so descriptive that nobody questions my bills, really. I see. There was one time, way years ago, the guy was a complete jerk. I never should have signed him up as a client. There's a lesson there. It's better to say no than to sign up. Yeah.
Always listen to your
Getting a big retainer is like, you know, doing a divorce at $10,000. If they, you know, want to negotiate with me, I was like, hey, you know, you can negotiate with somebody else. I'm not interested, because I know that kind of person, if they want to negotiate on this, they're going to be trying to negotiate on the bills that they receive later on, and so I don't want that kind of client. What else were we talking? Oh, billing. QuickBooks is what I use for since I do everything, I don't have a billing person typing up my billing. I've used QuickBooks ever since I started because I talked with my tax preparer, asked them, well, and they said, oh, well, use QuickBooks because it will coordinate with, it's compatible with the tax preparation program we use, and it makes it easy for us. And so I'm, well, okay, that works. There's a number of things, it works fine for what I do. There are a number of things that it doesn't do that some of the other programs, like you mentioned Smokeball, that may, there are a lot of the time slips in these other programs that, will automatically, track your time and automatically do your billing for you and things. QuickBooks does not do all that. I have a sheet, and the way I was taught when I worked at the insurance defense firms, I manually with a pen and paper write down everything, and then at the end of the month, I take right over Yeah, it's kind of old-fashioned, but it works.
So I'm all Mac. Even at the law firm I'm at, who's PC, I have a Mac with 2 Mac screens and 1 PC screen with their stuff up on it. And I use Mac-specific billing software, and then for the accounting side, I use QuickBooks because it's cross-platform. But, I would look at a legal-specific billing program. QuickBooks has significant limitations as a billing program. It's great for accounting, not so great for billing for consulting type hourly work. It might be good for manufacturing. So look at the different specific legal billing programs, because they do offer a lot of features, because you're going to be a business owner. You need to be able to understand the financials and track what you're doing and see, am I making any money when I do X or Y? And at the end of the year, am I making money, and how am I doing? And so the data analytics that you can get both from the billing programs and from your accounting program are important to you as a business owner. When I was a solo, at the end of every month, it's like, all right, how many hours did I bill? What can I afford to do? Can I make my mortgage this month, kind of thing, to see, how am I doing? Because as a solo, I never knew from month to month. It was, 1 month was awesome, the next month was horrible, and then 2 months are great, and so you don't get the kind of the firm issue where if you're having a bad day, you might be having a good day for billing, and it kind of smooths out. So tracking that stuff, I think, is more important for solos and small firms to keep ahead of those accounting issues, so you don't have to borrow out of your line of credit or your credit card.
I wanted to make 2 points on billing that just occurred to me. One is, I have a number of clients at a fixed monthly retainer, and it's usually a good deal for them. They get a lot of value for that, so they have kind of a menu of this is all you get for this monthly price, regardless of how long it takes me. And it was good at the beginning when I founded my firm, because I knew I had that set receivable from that. Maybe there were 5 people with that kind of plan, and it just really helped just know that I was at least going to make that much money, And it was a good deal for the clients because it was predictable in their budget. They knew exactly what their output was going to be every month. And usually it came out pretty even. Like at the end of the year, I never took a big bloodbath and overworked. And if I did the next year, I'd kind of recalibrate. But if you are in the kind of practice that allows that kind of fixed fee arrangement or monthly retainer, I would encourage you to do something like that.
The only thing I would say on this subject, your IOLTA account, the trust account, make sure you do that right. Talk to a CPA if you need to up front to make sure you set up your accounting right. That's one of the single biggest areas that the bar will go after you for and will take your license. Don't mess that up. Don't commingle the funds. Make sure you account for everything. Give the clients back their fees.
Okay, so the reason he's saying that is that when you take that kind of money, that goes directly into your trust account, and you don't transfer that to your operating account until you earn those fees with a retainer type arrangement.
So you guys send out your bill, wait a certain time period for the client to object, and then transfer?
No, like as soon as you send out your bill, you just take the fee.
I would do it as soon as I sent out my bill. I might wait a day or two because I forget to log in to transfer the money, but my bills would show how much I worked, how much the retainer was, and then how much is left in the retainer, so I can see how much I made, and it's also in QuickBooks, and then I can move that money across into my operating account out of the trust account. But that's one of the big areas that the state bar will go after solos, is looking at that trust account because of errors that get made. So.
And there is a handbook. If you go onto the California State Bar website, there's a PDF that you can download.
For the IOLTA?
Yeah, and it gives you all, it's a little tedious to go through the whole thing, but it gives you all the ethical rules on the handling of that.
Having a good CPA, at least initially, who sets up your chart of accounts for QuickBooks or whatever accounting system you use, and can help walk you through how to run the IOLTA properly and set it up in your accounting package, is worth that initial fee. Even if you don't use him or her down the road and you do your own tax returns, having that initial GL, the general ledger set up, and learning how to use it, what it means, and how to operate the IOLTA transfers is worth spending some money up front to get that right.
Does your policies cover bar defense if there's any issues, just out of curiosity?
So, we just filed a new universal policy that will go into effect in 2020 that will actually have a mark reimbursement.
Cheaper?
We dropped our rates actually this year,
Okay.
so,
Well, I like to hear that because you're our carrier.
glad to hear that.
I have a question actually for Dana on billing. So I was always taught from the malpractice perspective that you write down and you bill to capture a record of every single thing that you do. And that even then, if it's no charge or there's a discount, so that 8 years later, which is not unrealistic if there's a legal malpractice action against you or your firm, or you've moved on to another firm, or one of the associates, if you have one associate working for you and they moved on, there's a real, oh, there's this telephone conference on this day regarding advising client of plaintiff settlement offer. You know,
Yes.
like contemporaneous back in time.
Yes,
If there's not the memo, which would be the better course, but
but document, and your billing is one of your ways to document. It's one of the communications your client gets from you every month, no matter what. If you have an active matter going with them or active ongoing services with them, and so document, and your billing is one way to document because you always want the roving record.
Well, I had that come up. When I was an associate, I finished a litigation matter, and the client lost the case, and he deserved to lose. I'm pretty sure he lied in the arbitration, and he came back to the firm and confronted the partners saying it was my fault. And I went back and looked at the bills, and I found that he had taken one of the contracts that I drafted for him, and he altered the date. And I was able to prove that based on my billing, and he had used that in the arbitration. So he was trying to blame me for something that he altered and submitted as fraudulent evidence in the arbitration, and my billing records, which were detailed from the insurance defense firm, caught him. And he walked out with his partner very quickly when that got presented to him.
Yeah, you've kind of alluded to this issue, client selection.
Go with your gut.
Is that it?
I mean, if someone negotiates with me, the answer is no, thank you. This is my rate. This is what I want. If you're not happy, I am happy to give you other names and numbers, or give you to the Bar Association Legal Referral Hotline. But after almost 30 years as an attorney, I've learned to trust my gut. If that initial phone call sounds weird, I don't need your business. Thank you very much. There's 100,000 more attorneys in California that would be happy to talk to you.
And I'll just add, when I did legal mal-defense work, I can't tell you the number of the cases that somebody walked in the door and said, I knew from the first time I met the client in person or for the second week of this case that I shouldn't have this client.
But that's so hard when you're just starting though.
it is, but it's better.
I don't disagree with you. I just was hoping for something more than trust your gut, but maybe that's all there
I
is.
think
you
people
know.
try to negotiate your fees before
That
they're
I
even
understand.
engaged. I
Yeah.
had a great phone call 2 weeks ago with a guy who's starting a biotech incubator in Alameda. I don't know if you were. Phenomenal sales guy. Like, I just got VC funding and da-da-da, and this and that. It's going to be wonderful. And I was like, oh, yeah, sounds great, great, great. Yeah, I was going to do his industrial lease. It was a big facility. I'm like, oh, this sounds awesome. He goes, so what I'm going to need from you is, can you defer collection? What? He's like, well, you know, I really need to retain as much of the revenues we have. Blah, blah, blah. I said, no. You know, and it sounded great, but I can't finance his business.
No.
I would say some advice that I got when the firm I worked for 20 years ago, we did, like I mentioned, we had yellow page ads, so we got all kinds of people coming in and interviewed them, and we did personal injury and we did family law, and the partners, their advice was that with the personal injury, if the client seems crazy, don't take the case. You want to stay far away from it. But with family law, if you don't sign up the crazy ones, you won't have any clients. So it
That's why I don't do family law.
depends on, what practice area you're in, I think. But get the retainer. I absolutely get the retainer.
I am so admiring of people who do family work at the trial court level, because you're just dealing with people who are just in the most miserable, disrupted parts of their life, and they are at their worst. And I do appeal to family law matters, but that's about as close as I want to get to it. I mean, it's just.
So the next topic is filing and information, basically records retention. How does the insurance company look at us in this regards?
Before I answer that, I just want to add one thing on the prior topic. If you trust your gut and do not take the client after the initial representation, make sure you document that. Send a letter to them, send something in writing to them saying, I am not your attorney, so that is no doubt if they come back saying, oh, but I retained you, or you're my lawyer, I met with you, you really just want to document and make sure that's very clear and have those letters out there.
But can I add something before you go?
Yes.
It's my documentation of communications with clients. So I recently represented a company with 3 major shareholders. I made it clear that my client was the company and not any individual shareholder. That needs to be crystal clear. But also, what I was doing has implications in tax, of which I can't profess to be an expert, and there's some estate planning aspects as well. And so while I said verbally to them, I encourage you, each shareholder, to take this agreement that we've all agreed upon, and before it gets signed, talk to your tax advisor, talk to your estate planning attorney to make sure that it doesn't compromise your position. I haven't done that in writing yet, and following this discussion, I'm going to do that this afternoon.
Document everything. We all know if it's not in writing, it didn't happen. It doesn't exist. No, so just for record retention and filing, you want to make sure you're not getting rid of everything immediately. You need to keep records, you need to hold on to them, you need to have everything. If there is a suit for malpractice brought against you down the line, you need to have your file to back up what you have to say and to back up your defense there. So really, not only document it and put it in writing, but then hold on to it for a while.
How long do you recommend hanging on to files?
It varies completely by practice area. I mean, if you're an estate attorney where they could be coming back 30 years down the line, you probably should hold on to something forever. If you're a PI attorney and the case is over and done with, it's going to be shorter time period.
You had a question?
Same question. So 7 years you think is sufficient for a non-estate matter?
So I would defer to your record retention policies, but I mean, 7 years is the number I've always typically heard, but that's not a hard number that we as an insurance company put out, but
That's a tax
issue.
So one of the issues, put it in your fee agreement. In my fee agreements, when I was a solo, I put in there that once our representation is terminated, if you want your file, you have X number of days to request it, otherwise I may destroy it. And I was pretty much, other than litigation, I was paper-free, everything was electronic. I keep my electronic files, and I still have the stuff from when I started graduating law school. It costs nothing to keep electronic files. Can't read some of them, but I have them. But for paper, I don't want to store that paper forever. That's expensive. I mean, the old law firm I was at had a huge warehouse with just bankers' boxes of paper. And when I started, they were downsizing and they couldn't find half the clients to tell them, do you want your file? And it wasn't in their fee agreement. And so
They just kept it still.
Yeah.
it's like, do we destroy it and risk them coming back and wanting it because we didn't tell them and we can't find them? So put it in your fee agreement.
I've been deferring a very painful process, and that is retrieving from God knows where, maybe in Dublin or Pleasanton, all of my banker's boxes from 10 years ago that I just need to, because I'm paying like $60 a month. And I don't even know, but there's boxes and boxes and boxes. Yeah, that's
Good price.
and I just need to get rid of it, It's over 10 years old.
Shred companies, I'm sure.
I shred once a year what's in storage.
Yeah.
Eventually I'll get over what the
What was
guys
left
and
to
I
you.
had that was left to me. I'm close.
All right, we have about a half hour left. I think we should have time management.
Well, I don't want to disrupt the time management, but I was going to quickly say that I got a scanner a few years ago, and that was wonderful as far as record retention, because whenever I want to shred something, I scan it first, I have an electronic copy, and then shred the hard copy.
Or if you scan it right when it comes in the mail, then you don't have to worry
Then
about
it's already scanned, that's right. Yeah.
Records retention. So time management. Do you care that we manage our time poorly?
We'd like you to manage it well, but that's not something we oversee and spend questioning your hours on. But no, I mean, managing your time is something that is important, because if you don't manage your time properly, you'll unhappy clients, and unhappy clients lead to lawsuits. And that's not good.
Then we get to talk to you.
Exactly.
I keep a weekly task list that I review every Friday with my paralegal and take things off that have been concluded and move things to red. I have all this highlighting is how urgent it is. It gets a different color, and that's how kind of I manage my active matters. My most productive days in the office are days that I have an incredible amount of things to take care of. If I have kind of a relaxed schedule, I feel like I get nothing done. So I'm just a person who just needs the pressure of time to be sort of efficient.
I feel like I'm not the right one to be talking about time management. It used to work much better, when I was single and didn't have kids, and I would just work, and I had all kinds of time in the office, and everything got done. It was great. Now I'm, working from home and coaching my kids' basketball teams and things, and it seems like I'm, always scrambling to try to even just go through my mountain of emails in the inbox before my workday is over, much less actually get anything done. But so you got any good ideas from time?
I mean, there's a number of systems that exist that people have gotten rich off of. I mean, the one that I like is called Getting Things Done. It's a very popular system. You can get the book, I think it's David Allen, Inexpensive. And it basically is kind of what Anina does. It's keeping task lists. And the theory is that back before there was a lot of white collar workers, that as a blue collar worker you could get satisfaction because you could see I put so many bricks in the wall, or I laid so many feet of railroad, and you could see what you did that day. But as an attorney, I moved some electrons around, and I might have sent out some documents. You don't have that satisfaction of there's actually something visible at the end of the day. And so the theory is your visible reward is crossing things off that task list, which kind of is what Anina does. So, and if I get stressed and I'm feeling like I'm lost, I make a task list so that I can see, all right, what do I have to do? What do I need to prioritize? And then other days, if I'm feeling okay, I don't need to worry about it. But that helps reduce my stress when I start getting really stressed out, is I just make that task list and put everything down, no matter how small. You had a question.
Yeah, does time management include calendaring? Because I'll bet the insurance company cares about calendaring.
We do.
Yeah.
We actually require that all of our insureds keep 2 forms of a calendar and cross-check it at minimum of weekly, meaning not your Outlook shows up on your phone and your computer, but you have either 2 completely separate systems for calendaring, or you keep a hard diary still and your computerized system. Because what if that Outlook goes down and you miss a deadline because your Outlook was down for a day and you totally forgot that you had a filing date or something like that? And so we do require dual calendar systems to be kept.
And did the calendaring systems have to qualify? So for example, they have like CompuLaw,
No.
which calculates everything and then some for your deadlines. But
No.
you just want like an Outlook and a paper calendar.
Right, or whatever you may use, because everybody's practice is different. What you may need will be very different than the appellate attorney, who maybe has a couple deadlines at most a month, versus a busy litigator doing class action work who might have multiple deadlines in a day. And so we don't dictate what types of calendars you use. We leave that up to you of pick what works for you, but have some kind of backup.
John.
Yeah, one thing I do, the first thing I do is I do a kind of sort of a case flow chart or a timeline, and I do it, line up all my cases down on one end of the paper, and then I take it out, take all my tasks out for each of those cases about 3 or 4 months out. And so I know where I am at each given part of the month, you know, how much I have going and what's due next, and then what the deadlines I take from that, I put in, you know, I put into my phone and my calendar on my computer or on my phone, and you know, so I've got backups for you know, for recording what my deadlines are.
So you're using like a Gantt chart.
Huh?
I think it's called a Gantt chart that lays it out.
Yeah.
Anybody else have any tips for time management? Since attorneys are one of the highest professions for drug and alcohol abuse because of the stress that we are under. And you know, time management helps to reduce that stress. So what do other people do? Yes?
So I love reading about this topic. I do. I feel like I've read so much. I'm not an expert, but a couple of things that have helped me. So I'm definitely a list maker. So I like creating a task list every day. But one thing that's helped is to approach it like, okay, like prioritizing the list. And so I read this somewhere. It's not my original thought, but like if I only accomplished one of these things today, what would I feel good about, right? And so, I mean, it sounds so simple, really, but I take that approach. So it's like number one on my list isn't necessarily the thing I would always start with, but if I think about it, okay, if there was only one, like I feel like all these things are necessary, but if I only did one and I still feel good about my day, that's going to be number one on the list. And then there's another thing I do, and this was recommended, was at the end of every day, think about like what went really well today, what didn't go so well today. So something, and to fold in like self-care. So often it's like, gosh, I really wish I had exercised today. I didn't do that. But that's really important, right? For your mental and physical health and competency as a lawyer. And so I found that like over like several days, I would like track sort of what my response was. And it's like, oh my gosh, like, you know, 3 or 4 days a week, I'm saying I wish I exercised today. So then I was more conscious about incorporating that into my day, and then I felt better and I was more productive. So.
I think it really works. It's kind of what happened to you is I have a lot of stuff going on. So if you have a lot of stuff going, you kind of get a lot more done. You got downtime, you can forget it.
Right.
So.
I think too, with the whole task list thing and having a narrative bill, at the end of the billing cycle, I look at my pre-bills at all the narratives and I have my task list there, and I'll see, oh, I sent out a demand letter. That was like 20 days ago. I never heard from that other lawyer. And so then I can see what's outstanding. It slipped my mind because the ball's out of my court, but it needs follow-up. And that's what refreshes my memories when I see everything that I didn't.
Well, I kind of do that too. I kind of write it all out, and then I kind of add it up as I go along, and you can have your own kind of separate goal. Like, I want to make sure I get at least 6 hours of billing in today. And then you can kind of see as you're going along, it's like, I'm getting kind of, you know, light here. I need to do something else. So.
All right, so our next topic, oh, this is the best one, insurance.
Obviously the best one. Okay, so legal malpractice insurance is very different than other types of insurance that we carry, such as auto insurance, in a few ways. One, it's a claims-made policy. It's often burning limits, and there's often consent to settle clauses in there. So those are 3 kind of things to be very aware of. Burning limits means, for those that aren't aware, that the moment money's spent, the policy starts to reduce. So if you have $1 million policy and you have $250,000 in defense costs, there's only $750 left to settle in there. I know that we offer a $50,000 claims allowance, that you spend that $50,000 before you actually start burning though, and that's because we found that the majority of frivolous claims settle for under $50,000. And so that's just something to ask about when you're looking for insurance, is if there is an expense allowance or if you have the ability to purchase that to go with it. The fact that it's a claims-made policy, what that means is so like your auto policy, it's the policy that was in place when the accident occurred. This is the policy in place for a professional responsibility policy on the date that the claim is actually made. Now that's important because that means you also need to have something called prior acts coverage, or it's also can be referred to as your retroactive date. And so you need to have two pieces in order for a claim to be covered. You need to have insurance in place the day the claim's made, but you have to have a prior acts date or a retroactive date that goes back to before the alleged incident occurred. Does that make sense? Okay.
Does the $50,000 criminal defense, does that go into your rating? If you get a bunch of those little ones that resolve out because you're getting a bunch of frivolous claims, or how does that play with your rating?
So for rating, that's kind of actually one of the reasons for us, at least, that we have an attorney and the head of the underwriting department, is we're looking at what really occurred. Are you having frivolous claims? Well, if you're having a bunch of frivolous claims, you need some client selection probably to think about that. But one claim that is something that you defensed or something that is frivolous and goes away for a little bit of money is going to be looked at differently than something where our policy limits are paid out because there was something that was done wrong. So that kind of answers your question, but.
So do you guys select the panel attorney to defend, or can the insurer select?
So we have panel counsel, and I would defer to our claims department, unfortunately, on how panel counsel is appointed. Some things to be aware of is the rules of professional conduct, and its rule, the new rule is 1.4.2, does require you to let an client know if you do not have insurance. So I would look at that. There's corporations requirements if you're a corporation for insurance, and there's requirements if you're an LLP for insurance as well. For the corporation requirement, it's very convoluted, and I would look at that yourself if you're a corporation, but know it exists. And if you're an LLP, it's $1 million in coverage for up to 5 partners, and then every partner over 5, it starts to add on a very specific amount. So something to be aware of when you are purchasing coverage with respect to what limits you want. And limits, most common questions I get is, well, what limits do I need? Well, we don't give recommendations on limits, but the things that I always recommend that somebody considers are, what kind of law do you do? What are your clients' value? What are your average case value? What is your average case settled for? What's your average case value? And just what your own assets are too, and what you're looking to protect. And so kind of taking all of that into play, playing with cost-benefit analysis and dollar amounts and what it's going to cost you to really come up with what limits you do need. And minimum limits for us start at $100,000 per incident, $300,000 in the aggregate, and they just go on from there.
Dana, can I ask you, so for a person who's going to leave a firm and start their own firm, would they get a policy that had a tail for what they did with their own firm and then get their own prospective coverage?
No. So typically the tail portion of it, you want to have that discussion with the firm you're leaving. Okay. Some policies will allow you to buy an individual tail on it, some won't, and some the fact that there's coverage in place still for that firm, your acts are still covered for the time you were at the firm. And tail coverage, for anybody that doesn't know, it's an extended reporting endorsement that it stops your new acts coverage, but it continues to cover you for those prior acts for the time that you had that coverage in place.
You would buy that from your old policy, like you would go to that carrier?
You would go to your current firm that you're leaving, and you would talk to them and find out what your carrier that you're leaving requires and allows. Let's see. Typically cooperation clauses. If you ever do have a suit, make sure you're cooperating with your insurer. Trying to think. So another thing to kind of be aware of too is sometimes there's cyber coverage that is either included with the policies or that can be purchased out there. And I don't know if any of you sat through the cyber this morning. I sat through that panel. It was really interesting. So like our policy is a $100,000 cyber policy that's included with it. And so that's something you want to be asking about when you're purchasing insurance is, in addition to the actual insurance, what else is part of this policy? What else is included? What else is my insurance giving me, such as a cyber policy or access to MCLE?
So what is your cyber policy covering that you wouldn't get an outside cyber or CGL policy?
So we have a $100,000 cyber policy that comes with every policy purchase, no matter what the policy limits are, and it is included in the price. And it covers everything from ransomware was put on your computer, what do you do? You call the cyber people immediately and they help you through it.
They buy you a Bitcoin?
Yes, which if you learn Bitcoin, it's not easy. If anybody else was there, it's not easy to find Bitcoin or how to purchase it if you're a normal person. And then up to my associate or my paralegal lost their laptop, and now there's all the privacy considerations that come into play, and what do I have to do, and who do I have to notify, and they help you through that.
Well, that's awesome.
Another thing, kind of in the cyber area, I'm totally going to segue for a moment, but is also the, right now we're seeing this alarming rise in wire fraud cyber claims, and they don't actually fall under the cyber policy at this moment, but it's changing in instructions on where to wire money to. It comes through, and if you're on your phone, it'll look like the email address is somebody you know. It could be a client, it could be an opposing counsel, telling you, oh, here's actually the instructions on where to wire the money to, where to wire your monthly fee, where to wire your settlement proceeds to, and then people just go ahead and do it. And I mean, we have one right now that's over $750,000 that occurred on. So something to be aware of, and just really we're putting a PSA out there right now for every attorney. If you ever get a change in instructions, pick up the phone. Don't call the number on the email that you receive, but pick up the phone to the number, look into your Rolodex, look through whatever you may have and find the right number for that person, call them, and just confirm it over the phone that it's really actually them changing the instructions. Totally segued there, but are there any questions on legal malpractice policy?
How about deductibles? What's offered and how much does it affect the rates?
So the amount of the deductible can affect the rate. The higher the deductible it is, usually your rate will go down a little bit from that. For us, for a solo, we offer deductibles of $2,500, $1,000, $2,500, and $5,000 with a maximum deductible of $5,000 for a solo. We allow a firm of 4 or 5 attorneys to go up to $10,000, and then you can kind of go up from there. But for us personally, like once you get above the $10,000, you're not getting as much of a discount because we do work with solos and small firms, and we like the deductible to be something that they feel is actually affordable if they get sued, and that it's not going to bankrupt our attorneys.
Yeah, so the cyber this morning was pretty interesting, because I was there too. And I mean, the city of San Pablo got hit with a wire transfer scam. They lost money. One of their AP clerks got a wire from their boss, or an email from their boss that said, you need to wire this out to our vendor immediately. They did. It was fraud. And the money was gone. And the Contra Costa DA went and investigated it, and the money's gone. So yes, it's very real, and those scams are going after attorneys because they know you have trust funds. So be very careful with your trust funds. And I mean, one that's also out there that our bar has sent warnings about is the, hey, I need to hire you to collect this money from Joe Blow who didn't pay me, and then you take the case, they send you a check, because I actually did one of these because I wanted to see what would happen. They will send you a check, cashier's check, and I walked it down. It was drawn on Chase Bank, and the Chase Bank security officer here in Walnut Creek came out. She couldn't tell it was fake, and I told her this is going to be a fake check. I even had the FedEx envelope. She went back and came out 15 minutes later, and she's like, yeah, this is a pretty good forgery. So they are very realistic, and once you put that, the scam is you put it in your trust account, then they immediately call you, oh, can you send me my check, you know, because it'll clear pretty quickly. And then the bank will realize that it was a fraudulent one once it hits their main office. They'll pull that money back. You're personally liable, but you've already wired it out or sent it out to this fraudulent person.
They're very sophisticated. They're doing stuff like watching court documents and seeing that a notice of settlement was filed on a case, and then they're targeting those. And we've had ones where big firms have been targeted. We've seen it, everybody. Nobody's immune from this, and so just know that the cyber criminals have gotten very sophisticated, and once the money's gone, they're usually foreign, and you're never seeing it.
In the real estate profession, we get emails constantly from the association telling us, let our buyers know, don't wire money to take it directly into the title company because they've been getting it.
Yeah, so be very careful with that.
We've been delivering settlement checks the old-fashioned way, dropping off the check with a messenger.
Yeah.
No electronic, because
That's
that's
what I've
a
always
big
done.
thing. They're like, they search behind, like, if they can get in your system, even if they're not at, they know like settlements are coming, or they're targeting the plaintiff attorneys that often have settlements. And then they're looking and so that they can think they can send an email to change where the wire funds are going.
Yep. Yeah, so be very careful with that stuff. And the other topic we had on here, we discussed it last night. If you're going to be a solo or a very small firm, health insurance drives everything in our economy. While I was a solo, my wife worked for St. Mary's College. She provided health insurance. She retired in January, and when I went out and priced what it would cost to replace her basically top-of-the-line policy, it probably would have taken over $60,000 in pre-tax revenue to cover what her employer was paying for. That's a lot of work you have to do just to get that health insurance. So a lot of the solos I know, you ask them, oh yeah, my spouse works for XYZ and I get my insurance through them. Because it's expensive as a solo to provide that. And you're using after-tax money, not pre-tax money where you would be if you're an employee. And there's actual law firms where partners have stepped down and become employees because the firm couldn't afford to pay for their insurance, but as an employee, then they can deduct it. And so that is, when you're considering the financing and how to operate, that drives a lot of stuff nowadays, unfortunately.
But the other type of policy we should just talk about is the general liability policy. So because I have an office place, I have general insurance, liability insurance, and I've actually used it once. I was really pleased with it. My car got broken into, my laptop was stolen, among other things. And not only did I get the value of the laptop and all that stuff, but I got the time of the person who had to restore files, like the IT consultant's time was all covered, so that was nice, helped soften the blow of being ripped off.
And I'll just kind of add along those lines, something like employee theft is not included in your legal malpractice policy, and that's something that a lot of people will assume it's included, so just know that that's not, and then you would want to look at other types of policies to have that.
And if you're working out of your home, talk to your homeowner's insurance broker. See what's covered and whether or not you need to add additional coverage to your homeowner's policy. If you're operating your office out of there and there's a fire or something, you lose your computers, that may or may not be covered under the homeowners, but if you add that endorsement that you're operating a business out of your home, now you potentially have coverage for that loss. So that's one thing that people who operate out of their home sometimes don't think about, is looking to see what that homeowner's covers and whether or not you're covered. So.
I was going to say, if we have another minute here, I'd talk a little bit more malpractice insurance. Picking the coverage amounts. For me, I have a lot of business from legal service plans, union plans and things I mentioned earlier, and all of them have requirements that I carry malpractice insurance, and I have to send in the declarations page every year so that they know that it's still in effect, and they have minimums coverage that they require me to have. So that sort of set my minimums there initially. I have bumped it up over the years since then, and it really doesn't cost much more to have like $5 million in coverage than it does to have $300,000 in coverage. Not a whole lot more, really.
Depends on what you do. But
yeah, depends what you do. And then on the deductible, how much would you save? Again, there I thought, well, I'm going to max out my deductible, which was $5,000, because I want to save some money. But my broker said, well, you're really not going to save hardly any money at all. It's very little savings for the different amount of deductible on that. And as far as numbers because it was asked earlier, how much do these policies cost? For me, being by myself, doing family law, it's $5,000 a year is approximately what the policy cost premiums. It varies, over the years. It comes down to about like $2,500 sometimes. And I have asked my broker why does it vary sometimes, because it does come down sometimes. And he said, well, it depends on how many carriers are in California. when it's up to 5,000, then all the carriers look, what great business in California. We're all going to go in and write malpractice insurance in California, and they rush in, and all the competition drives the policies down to 2,500, and then they decide, well, it's no longer profitable. We're backing out of California with this malpractice stuff. And then there are only a few, like your company is still writing, and
Yeah,
again, it
over
goes
40
back.
years.
Yeah, still there. So it fluctuates, but
And I will also
Right,
add
what
in,
it
when I
is.
talk about prior acts, so you typically don't come in at mature premium, so your policy is going to start off in your first year as practicing as your own firm at a lower premium than when you're fully mature on your prior acts. So when you come in, say you started a firm today, you bought a legal malpractice policy, you're what's called no prior acts coverage, so your coverage doesn't go back to tomorrow, it starts the day you bought that very first policy ever. And so for us, you're at 48% or 42%, but less than half a full premium in your first year. And so you get little climbs as you go up till you hit the full premium at 8 years or whatever your carrier's prior acts term will be. So you definitely will typically start a little bit lower, expect to see some rises over at least the first 5 years, 5 to 8 years, but know that that exists and that's coming.
And our last topic is on technology. So you've kind of already heard that they're going to be offering you a $100,000 policy if you go with Lawyers Mutual, and other carriers may be doing something similar for cyber insurance. But technology is how solos compete. I mean, it allows you to leverage a small investment to compete against the bigger firms. I've been a Mac guy forever. I've had Apple since 1981. So I don't really use PCs. I'm having to at my new firm. Like I said, I have a 3-screen setup, and one of the screens is dedicated to PC stuff, and the rest is all my Mac stuff. So, and you guys are probably both PC.
Yeah.
exclusively Mac.
Oh,
I got an iPhone and an iMac, and for a long time it has created some challenges with the software, because a lot of software companies, legal software, do not produce Mac compatible stuff. I've been able to use the Parallels program and run Windows on my Macintosh, and then run the software that way. I don't know, technology, we could talk for the whole 2 hours on nothing but technology here. There's so much there.
What I really want, and I have to believe it's out there, so I use Sage Time Slips as my timekeeping program, and last time I checked, they don't have an app. I'm desperate for a timekeeping app.
Bill for Time.
Rainmaker?
Bill for Time does.
Okay. What?
Bill for
Bill
Time.
for Time, okay.
With the numeral 4.
Okay.
Yeah, so I mean, technology is a cutting edge. I mean, it's good and bad. I mean, I have my SEO client is a group of 20-somethings, and I'm their general counsel. And now they've added me to Slack, which is a workplace communication software that allows texting and real-time interaction. So I can't go anywhere. I mean, my watch tells me, hey, they just sent me a Slack, and it pops up on my phone and on my computer. And the cycle of question and response, I don't think we can get any smaller at this point. Whereas when a lot of us started, the firm I started at, the partner at 5 o'clock, he would walk over and unplug the fax machine. So that people couldn't communicate with us after 5 o'clock. Every day he walked over and unplugged that fax machine. So you don't see that anymore. And it's kind of part of our life. It drives some of the stress, but it also lets you work much more efficiently because of the computerization. And I scan everything in. When I was a solo, I had a scan snap by Fujitsu. The mail comes in, I drop it in, hit the button, it scans into Acrobat. I save it directly to the client directory, and got it forever.
Okay, so what I don't like is I have a client who's trying to make me use something called Basecamp.
Okay.
And tasking me to do things, and I feel like, here's what's on your plate. I'm like, that's not on my plate. Reminders every week.
It's a task management software.
But I don't work for you, like not like that. No, I've got my.
But that becomes a billable opportunity that you can potentially then negotiate with a client, either for a set fee a month or whatever. And you have to train them, just like we have to train our clients. If you're going to call me all the time, you're going to get a really big bill at the end of the month. So maybe you want to dial back the phone calls and collect all your information and make one call rather than 10 calls. The same thing with
Point two, base camp.
And like with Slack, I mean, that's one of the things I'm having trouble with, and I kind of at the end of the day say, all right, they sent me this many messages, I invested this much time, and I put, Slack with client, and I, communications and what I did, and then bill a block amount for what I think I spent dealing with the Slack communications. And, that's coming more and more as people want to communicate in those ways. And I think we, as attorneys, have to figure out, because all we have to bill for is our time, and whether we flat fee it or bill hourly, those tools have to be worked into our practices, and we have to figure out what's the most effective way to capture the time and get paid for it.
Do you worry about preserving your communications in Slack for client record-keeping purposes?
The client owns the Slack data. They've added me to their Slack channels, and I don't know enough about how Slack keeps the recordation. You can actually download, you said it, but you can download the file. So if there was an issue and I needed to, I can download it, but I've been on it now with them for maybe 2 months.
So you set, Slack is automatically set to unlimited and it keeps it forever unless the company sets it to something else.
Sorry, go ahead.
I was going to mention, along the lines of keeping communications with emails, I create subfolders in my, law practice folder in my emails for each client, and then every email that comes in or gets sent, I file it away in my email thing, so it keeps the communications there.
Text messages too, if you get a text message from a client that's telling you to do something or something that you should have a written record of it, screenshot it.
Okay. I was going to ask about text messages.
Yeah.
Someone mentioned, I think you mentioned that some of your clients have your cell phone. So I'm not sure if they text you, but how do you keep record of texts?
I have
Or do you download them? Or, because that's such a critical part of communication now, and a lot of things get misunderstood or miscommunicated by text, so how do you cover yourself?
I have everything, everything's on here, and because it's Mac, it also syncs to my desktop and my iPad, so it's in multiple spots for the text messages, and if I needed to, those are easy to download on the Apple. I don't know as much on the Windows side, but I have clients that I have them send me screenshots for evidence. If there's been an issue in a case or before the case arose where they're communicating with an opposing party, I want those texts, and so a lot of times I'll have them screenshot it, save your phone, that's evidence, but screenshot it so I can see what were you guys texting about.
I would confirm in an email if it's a client communication to pursuant to our text messages yesterday, this is what we discussed or something, so at the very least you have that written record.
Well, you have the text. It's not like Snapchat where the client is snapping something and it's going to disappear in 30 seconds. So that's definitely one I would never use with a client. One of the disappearing message apps, that's probably a really bad idea.
So that kind of all goes, my question was going to be for those of you that are solos and you do everything primarily electronic, so you're not having the paper files. What are you doing for a backup, or do you have external hard drives, or are you using cloud backup, storage?
So things to look at when you need to have multiple backups. One, you need to have an off-site backup, because if you back up to a physical presence at your office and your office burns, your backup burns. So you need to have an off-site backup, which generally means you're going to somebody else's server, the cloud. And you need to look, when you communicate with whatever service you're going to use, find out who owns the encryption key. And what that means is, do you encrypt it on your end and send it to them so they can't touch it, or do they hold the encryption key so if you forget your password, they can send you a new password? Because if they hold the encryption key, their employees technically have access to your stuff. If you hold the encryption key, nobody but your employees have access to your stuff because that company can't touch your stuff. It's already encrypted by you before it goes to them. So that's kind of really the big issue is how paranoid are you? Because back in the late 90s when the first internet crashed, the newspapers went out and went to bankruptcy auctions and they bought the original servers. And all those people's data was there on those servers. The newspapers were pulling up medical records and legal records because backup companies had gone under and their servers got sold by the bankruptcy courts, because that's what the bankruptcy courts do. And that data was there. So I'm older, so that kind of made me paranoid. So, but it's, you know, that's one of the issues that you look at is who holds that encryption key. But if you hold it and forget it, your data's gone. You can't recover that because you forgot your key and no one else has it. And the key is just the password. Any other questions since we're at the end of our time here? We want to thank you all for coming, and hopefully we will see everybody back again next year for the 26th annual MCLE Spectacular.